Trump just suffered a devastating legal defeat that nobody saw coming. A three-judge appellate panel unanimously rejected his emergency motion in a ruling so decisive that legal experts are calling it one of the most consequential setbacks of his entire legal battle. And here's what makes this truly extraordinary. The decision didn't just deny his request. It systematically dismantled every single argument his legal team presented, leaving virtually no pathway forward except a desperate appeal to the Supreme Court that constitutional scholars say has less than a 15% chance of success. Hit that subscribe button right now because the next 72 hours could determine whether Trump faces trial before the election or manages to delay justice until after voters cast their ballots. So what exactly happened in that appellate courtroom that has legal analysts calling this a judicial earthquake? On January 16th, the United States Court of Appeals for the District of Columbia Circuit issued a 47-page unanimous decision rejecting Trump's motion to stay proceedings while he appeals a lower court ruling on presidential immunity. The three-judge panel, which included 2 judges appointed by Democratic presidents and 1 appointed by a Republican, spent nearly 3 weeks reviewing hundreds of pages of legal briefs before delivering a ruling that pulls no punches. According to the court document obtained by multiple news outlets, the panel concluded that Trump failed to meet any of the 4 required criteria for granting an emergency stay. Legal experts who reviewed the decision told reporters that the language used by the judges was unusually blunt for an appellate opinion, with one Georgetown law professor calling it a definitive rejection that leaves Trump's legal team with virtually no ammunition for further appeals. Here's the full scope of what the appellate panel concluded. First, they ruled that Trump failed to demonstrate a substantial likelihood of success on the merits of his immunity claim. The decision states that a former president does not possess absolute immunity from criminal prosecution for actions taken while in office, particularly when those actions fall outside the scope of official presidential duties. Second, the panel found that Trump would not suffer irreparable harm if required to face trial, noting that the inconvenience and distraction of criminal proceedings, while significant, do not constitute the kind of irreparable injury that justifies halting the entire judicial process. Third, the judges determined that delaying the trial would actually cause substantial harm to the public interest and to the government's ability to enforce criminal laws against all defendants equally. And fourth, they emphasized that the balance of equities strongly favors allowing the case to proceed, especially given the serious nature of the charges and the public's interest in a speedy resolution. Smash that like button if this is making sense so far, because what comes next shows just how thoroughly Trump's arguments were dismantled. The decision goes even further than simply denying the stay. In a section spanning 12 pages, the panel addresses each of Trump's immunity arguments individually and systematically explains why none of them hold water under existing constitutional law and Supreme Court precedent. According to legal analysts who spoke with CNN, this level of detailed rebuttal is relatively rare in emergency stay decisions and signals that the judges wanted to create a robust record that would make it extremely difficult for higher courts to reverse their ruling. One former federal prosecutor with 25 years of experience told reporters that when an appellate panel spends this much time explaining why your arguments fail, they're essentially sending a message to the Supreme Court that there's no legitimate legal basis for intervention. The ruling cites 73 different case precedents, including multiple Supreme Court decisions, to support its conclusion that former presidents are not above the law when it comes to criminal conduct. Here's where things get absolutely critical. The appellate panel gave Trump's legal team exactly 7 days to file an emergency appeal to the Supreme Court. That deadline falls on January 23rd, which is tomorrow. If Trump's attorneys don't file by that deadline, the stay is automatically lifted and the trial court can immediately resume proceedings, which means jury selection could begin as early as February 5th, according to the original trial schedule set by District Judge Tanya Chutkan. Sources close to the Trump legal team told NBC News that they are frantically preparing a cert petition for the Supreme Court, but they're facing a brutal reality. The Supreme Court has already declined to take up Trump's immunity claims once before through an expedited review process, and legal experts say the new appellate ruling makes it even less likely that the High Court will intervene now. A Harvard law professor who specializes in Supreme Court litigation explained that the justices typically only grant stays in cases where there's a genuine circuit split or a novel constitutional question of exceptional importance. And neither of those factors applies here since the appellate panel relied heavily on well-established Supreme Court precedent. Drop a comment right now if you're following along, because what I'm about to explain changes everything about the timeline. Even if Trump's lawyers file their Supreme Court petition by tomorrow's deadline, they face another massive obstacle. Under Supreme Court rules, the government will have an opportunity to file a response opposing the stay request, and that response typically takes 10 to 14 days. During that time, the lower court stay remains in effect, but once the government files its response, the Supreme Court could issue a decision at any moment. Legal analysts studying the court's emergency docket patterns say that in cases where the appellate reasoning is this thorough and unanimous, the Supreme Court often denies the stay with a brief one-sentence order, sometimes issued within 48 hours of receiving all briefs. That scenario would be catastrophic for Trump's delay strategy because it would mean the trial could proceed in late February or early March, putting a verdict potentially just weeks before the start of the Republican primary season's most critical contests. Now, here's what makes this ruling even more devastating for Trump's legal position. The appellate panel specifically addressed and rejected his argument that prosecuting a former president for official acts would chill future presidents from making bold decisions in office. The court's opinion states explicitly that former presidents are answerable to the criminal law for their conduct, like all other citizens, and no principle of our constitutional structure requires that former presidents be placed above the law. This language mirrors the exact reasoning the Supreme Court used in the 1982 case Nixon versus Fitzgerald, where they distinguished between civil liability and criminal accountability, making it extremely difficult for Trump's lawyers to argue that the Supreme Court's own precedent supports their immunity claim. A former Solicitor General who has argued more than 40 cases before the Supreme Court told legal journalists that when an appellate panel quotes Supreme Court language this directly, they're essentially daring the High Court to contradict its own prior reasoning, which happens extremely rarely. And believe me, the implications of this decision extend far beyond just Trump's criminal case. Constitutional law experts are already pointing out that this ruling establishes a powerful precedent that could affect how future presidents understand the limits of their power and their accountability after leaving office. A Yale law professor who focuses on executive power told the Washington Post that this decision represents a watershed moment in American constitutional history because it firmly establishes that the criminal justice system can reach former presidents for conduct that falls outside the core functions of the executive branch. The ruling specifically notes that many of the actions alleged in Trump's indictment, such as pressuring state officials to alter election results and organizing slates of fake electors, bear no resemblance to any legitimate presidential function and therefore receive no immunity protection whatsoever. Here's what multiple sources say is happening behind the scenes right now. Trump's legal team held an emergency strategy session on January 17th, the day after the appellate ruling was issued, to discuss their Supreme Court options. According to two sources familiar with the meeting who spoke with Politico, there was significant disagreement among Trump's lawyers about the best path forward. One faction argued for filing an extremely narrow Supreme Court petition focused solely on whether a former president can ever be prosecuted for actions taken while in office, hoping that framing might appeal to the conservative justices' concerns about executive power. Another faction pushed for a broader petition that would ask the Supreme Court to establish comprehensive standards for when presidential immunity applies, essentially requesting the court to create an entirely new constitutional framework. The sources say Trump himself insisted on the more aggressive approach despite warnings from some of his attorneys that overreaching in the petition could backfire and result in an even faster denial. Don't go anywhere because the most explosive part is coming next. What very few people realize is that this appellate decision also included a devastating footnote that directly contradicts one of Trump's most frequent public claims about the case. In footnote 27 on page 38, the panel addresses Trump's repeated assertion that he's being prosecuted for simply questioning the 2020 election results. The judges write that the indictment does not charge the defendant for protected speech or for questioning election integrity. Rather, it charges him with participating in a criminal conspiracy to overturn legitimate election results through fraud and intimidation. Legal analysts say this footnote is significant because it preemptively undermines one of the main arguments Trump has been making in the court of public opinion, and it could influence how media outlets cover his claims going forward. A former federal judge who now teaches at Columbia Law School told reporters that appellate judges don't include footnotes like this unless they want to send a very clear message that they've seen through a party's rhetorical strategy. The timeline from here is absolutely critical, so let me break this down step by step. If Trump files his Supreme Court petition by tomorrow, January 23rd, the government will likely file its opposition brief by February 6th. The Supreme Court could then issue a decision anytime after that. But based on historical patterns in similar emergency stay cases, legal experts predict a ruling would come within 2 to 5 days, meaning we could know Trump's fate by February 11th at the latest. If the Supreme Court denies the stay, Judge Chutkan could immediately lift the hold on trial proceedings and potentially begin jury selection by the 3rd week of February. However, there's a slim possibility that the Supreme Court could decide to hold oral arguments on the immunity question, which would delay everything by several months. But constitutional scholars say this outcome has less than a 10% probability, given that the court already declined expedited review once, and the appellate panel's reasoning is so thorough that there's little ambiguity left to resolve. Here's the kicker that has political strategists on both sides absolutely panicking. If this trial proceeds in late February or March, a verdict could come in April or May, right in the middle of the Republican primary calendar. Internal polling data from Republican campaigns reviewed by Axios shows that a criminal conviction could shift Trump's support among Republican primary voters by as much as 12 to 18 percentage points, potentially opening the door for other candidates to mount serious challenges in later primary states. But here's what makes it even more complicated. Some Trump allies are privately arguing that a conviction might actually help him by energizing his base and reinforcing his narrative of political persecution, while other Republicans worry that a guilty verdict would make him virtually unelectable in a general election against President Biden. A longtime Republican strategist who has worked on 5 presidential campaigns told CNN that the party is facing an existential dilemma, where they're basically hoping for legal delays they can't control because they're terrified of what happens if Trump becomes the nominee with a federal conviction on his record. Slam that like button right now because it genuinely helps this video reach more people who need to understand what's at stake. Now let's talk about what Trump's options actually look like if the Supreme Court denies his stay request. First, he could attempt to seek a stay directly from individual Supreme Court justices through an emergency application. But legal experts say this is a Hail Mary strategy that almost never succeeds, especially after the full court has already ruled. Second, his legal team could try to delay the trial through other procedural motions in the district court, such as challenging the jury pool or seeking additional time for discovery. But Judge Chutkan has already shown extreme skepticism toward delay tactics and has repeatedly emphasized the public's interest in a speedy trial. Third, Trump could attempt to settle or negotiate some kind of plea agreement with special counsel Jack Smith's office, but sources familiar with the prosecution's strategy say there is absolutely zero indication that Smith would offer any deal that doesn't include jail time, making this option politically impossible for Trump to accept. Here's what should alarm everyone, regardless of their political affiliation. The appellate panel's decision makes it crystal clear that no president or former president can escape criminal accountability by simply claiming that their actions were part of their official duties. The ruling states explicitly that the executive branch does not have carte blanche to violate criminal law with impunity when such violations fall outside the president's exclusive constitutional authority. This principle strikes at the heart of American democracy's founding concept that no person, regardless of their position or power, is above the law. A constitutional historian who has written extensively about presidential power told the New York Times that this ruling will be studied in law schools for generations as a definitive statement on the limits of executive immunity and the relationship between presidential authority and criminal accountability. And here's what makes the next 48 hours so absolutely crucial. If Trump's legal team misses tomorrow's deadline or files a petition that the Supreme Court quickly denies, we could see one of the fastest collapses of a delay strategy in modern legal history. Court watchers note that Trump has been playing a calculated game of running out the clock, hoping to delay all his criminal trials until after the November election on the theory that if he wins, he could potentially order the Justice Department to drop federal charges against him. But this appellate ruling, combined with the compressed timeline it creates, could completely destroy that strategy. A former White House counsel who served under a Republican administration told legal analysts that if this trial proceeds in the spring, it will dominate news coverage during the exact period when voters are making up their minds about the 2024 election, creating a scenario where Trump would essentially be running for president from a courthouse. Let me give you some perspective on just how rare and significant this kind of unanimous appellate rejection really is. Legal database research conducted by Reuters found that in cases involving claims of executive immunity or privilege, appellate courts grant emergency stays approximately 34% of the time, usually out of an abundance of caution about disrupting executive branch functions. The fact that this panel not only denied Trump's stay, but did so unanimously and with such detailed reasoning signals an extraordinary level of confidence in their legal analysis. A statistician who studies federal court decision patterns told journalists that when you see a unanimous ruling with this level of explanatory detail in a high-profile case, it historically predicts Supreme Court denial rates of approximately 85 to 90%, meaning Trump's chances of winning at the Supreme Court are somewhere between 10 and 15% at absolute best. Do me a favor and drop a comment below with your thoughts, because I'm genuinely curious to see perspectives from across the political spectrum. But beyond the immediate legal and political implications, this decision represents something much deeper about American constitutional democracy. The appellate panel's ruling reinforces a principle that has existed since the founding of our republic but has rarely been tested in such a dramatic fashion. No matter how powerful someone becomes, no matter what office they hold, they remain subject to the rule of law once they return to private citizenship. The judges wrote that allowing former presidents to escape accountability for criminal conduct would undermine the constitutional structure and threaten the foundation of our democratic system. These aren't just abstract legal concepts. They're fundamental guardrails that prevent American democracy from sliding into a system where executive power becomes unaccountable and uncheckable. Here's what Republican strategists are reportedly discussing in private conference calls right now, according to sources who spoke with The Hill. Some are arguing that the party needs to prepare contingency plans for a scenario where Trump is convicted but continues to run for president, which would create unprecedented constitutional and political chaos. Others are pushing for party leaders to somehow encourage Trump to step aside voluntarily, though everyone acknowledges this is virtually impossible given his personality and his continued strong support among the Republican base. A third faction is reportedly advocating for the party to simply embrace whatever happens and argue that any conviction is politically motivated persecution, turning the entire legal process into a campaign narrative about victimhood and democratic weaponization of the justice system. Meanwhile, a small group of establishment Republicans are quietly exploring whether there's any mechanism to prevent a convicted felon from appearing on primary ballots, though legal experts say state election laws vary widely and most don't explicitly prohibit convicted criminals from running for federal office. The situation is causing absolute panic in both parties, but for completely different reasons. Democrats are worried that if Trump is convicted, it could energize his base so much that it actually increases Republican turnout, while also creating a martyr narrative that makes it harder to defeat him in a general election. Republicans are terrified that a conviction could split their party between hardcore Trump supporters who see it as persecution and moderate Republicans and independents who would refuse to vote for a convicted felon for president. Internal polling from the Republican National Committee that leaked to Politico shows that in key swing states, a criminal conviction could depress Trump's support among Republican-leaning independents and moderate Republicans by as much as 22 percentage points, potentially making purple states like Arizona, Georgia, and Wisconsin virtually unwinnable for Republicans in a general election. Stay with me, because what I'm about to explain could completely change how this entire situation plays out. There's one scenario that almost nobody is talking about, but that could have enormous implications. If the Supreme Court does grant a stay and agrees to hear oral arguments on the immunity question, it likely wouldn't schedule those arguments until the fall term that begins in October 2024. That would push any trial until after the election, but it would also mean the Supreme Court would be issuing a major ruling on presidential immunity in early 2025, after voters have already decided the election. Some legal scholars speculate that the conservative justices might actually prefer this timeline because it would allow them to establish important precedent about executive power without being accused of directly influencing the election outcome. However, other experts argue that the court's conservative majority has shown little appetite for wading into Trump-related controversies after the intense criticism they faced for their handling of the 2020 election cases, making this scenario unlikely. Here's the situation we're facing right now. A unanimous three-judge appellate panel has issued one of the most thorough rejections of presidential immunity claims in American history. Trump's legal team has until tomorrow to file an emergency appeal to the Supreme Court that constitutional experts give less than a 15% chance of success. If that appeal fails, we could see jury selection in Trump's federal election interference trial beginning in late February, with a verdict potentially coming in April or May, right in the heart of the 2024 presidential primary season. The stakes have never been higher, not just for Trump personally, but for fundamental questions about presidential accountability and the rule of law in American democracy. Before we wrap up, make sure you've hit that subscribe button because the next few weeks will bring developments that could reshape American politics for a generation. Here's where things stand at this exact moment. Trump has approximately 24 hours to file a Supreme Court petition that will either buy him a few more months of delay or result in his criminal trial proceeding at lightning speed. Legal experts are standing by to analyze whatever brief his attorneys file, looking for any creative legal arguments that might give the Supreme Court pause. Meanwhile, prosecutors in Jack Smith's office are reportedly already preparing for trial, reviewing witness lists and exhibits, ready to proceed immediately if the Supreme Court denies Trump's request. And across America, 160 million registered voters are watching this legal drama unfold, wondering whether they'll be casting ballots in November for a candidate who is simultaneously a criminal defendant or possibly even a convicted felon. The constitutional crisis isn't coming, it's already here. The question isn't whether the legal system will hold. It's whether the political system can withstand the earthquake that's about to hit when a former president faces criminal accountability for the first time in American history. The Appellate panel has spoken. Their message is clear. No one is above the law. Now we wait to see if the Supreme Court agrees, and whether American democracy's most important principle can survive its greatest test. The next 72 hours will tell us everything we need to know. Pause for a second and hit that like button if you found this analysis valuable, and I'll see you in the next video where we'll break down exactly what happens the moment the Supreme Court issues its decision.